Hearing in the appeal, Dooneen Ltd and another against Mond.
Mr. Howlett.
My Lords, my Lady, in this appeal, I appear with my learned friend, Mr. McCall, QC, for the appellant, and my learned friends, Mr. Moynihan, QC, and Mr. Bartos, appear for the respondent. I say respondent in the singular because they've been whittled down from 2 to 1 in the course of the proceedings. I'd like to begin by giving the court my intended roadmap for my submissions, subject, of course, to changing course if that's what the court wishes me to do. And I propose to address the court in 4 chapters. The first is simply to state what we say the trust deed means, how it works, how one interprets it. The second is to look at the key authorities, of which there are only 3 in our submission. The third had going to be to deal with the case for the respondent, though I noticed that time is given for reply. I'm quite happy to press ahead with the case for the respondent, with discussing the case for the respondent whilst I'm on my feet, rather than waiting for one of us to have a second bite of the cherry later on, but I'm entirely in the court's hand when it comes.
Well, it's up to you. I mean,
yes.
You know how much time you have, and if you would rather spend longer in reply, addressing Mr. Moynihan's case after you've heard it, that's a matter for you. But one way or another, you've got an hour and a half to play.
Yes, well, I'm advised, my Lord. And then the final chapter will be the matter which was raised by the court last week, which is to look at certain material from the Scottish Law Commission and certain of the authorities discussed in that material. So with that roadmap, my Lord, and pausing merely to adopt formally the written case for the appellant, if I can begin with the trust deed. And this is set out at tab 12 of the core volume, and it's manuscript page 241.
No, it's actually, I'm afraid, it's nothing as grand as manuscript page. It's memory stick.
Oh, memory stick. Very well. Well,
manuscript sounds so much better, but
I'm afraid when it comes to these things, I come from an reconstructed older age, my Lord, and so I thought manuscript meant, MS meant manuscript. So yes, memory stick. But the good thing is that the page numbers are quite a good guide to getting to the right place. So it's 241.
You can always just refer to it as electronic.
Well, so be it, my Lord,
memory stick offense.
Yes. And before even looking at what the trust deed says, I want to make 2 very general points. The first is that this is a trust deed for the creditors, for Mr. Davidson's creditors. It is not a trust deed for the debtor himself. And I say that simply because if it's to be said that certain aspects of the manner in which the implementation of the trust works out could be thought to be inconvenient for Mr. Davidson, we say, well, that's just a consequence of the fact that this trust deed is granted for the debtors. The second point, very general, is this, that the trust deed is short and simple. If the court were to look, for example, at the Bankruptcy Scotland Act 1985, or more so the 2016 Act, the court will see that these are very substantial pieces of legislation. This is a 3-page document. It struggles to read 3 pages. It's short and simple, and one consequence of that is that it does not govern and does not attempt to govern every contingency which can possibly arise in the course of the administration of the trust. And I shall be saying, for example, that it does not specifically govern the circumstances which have arisen in this case, but I shall be saying also that one can find the answer elsewhere in the trust deed. So much for general points, my Lord. As regards the structure of the trust deed, the court will see that it's got a beginning, a middle, and an end. The beginning is concerned with the transfer of the debtor's estate to the trustee. That's clause 1 with the number that's been added. Clause 1 also identifies the estate. We've got then provisions for the trustee to receive a contribution from the debtor's income. And then we have in clauses 4 to 6 mechanics of administration, including under clause 6, Roman 1, power in the trustee to take possession of the estate. That's obviously important. And Roman 7, power to compound or compromise claims. So that's the beginning. The middle concerns the distribution of the debtor's estate. And once again, without looking at the words yet, what it does is provide an order of priorities. First of all, the expenses of the administration of the trustee, the trust's remuneration. Secondly, payments, and I do use the words here of the trustee now, payments of the debts due by me to my creditors as at the date I signed this trust deed. And then third, payment of surplus to the debtor. And I had these words from the trust deed after making payment in implement of clauses 1st and 2nd above. And I pause to say that that establishes a clear order of priority. The end of the trust deed is concerned with the end of the life of the trust, the discharge of the debtor from his debts, clause 10, the termination of the trust deed, clause 11, the discharge of the trustee himself under clause 12. Now, coming back to the point that this is a trust deed for the creditors, the central provision from the creditor's point of view, the thing that matters most, apart from the actual vesting of the estate in the trustee, is the manner in which the estate is going to be distributed. And if one looks again at clause 7, one has that set out clearly. For the trust deed is granted for the benefit of my creditors, and my estate is to be distributed as follows. First, I simply read the heading. I don't need more than that. Payment of expenses of trust deed and trustee's remuneration. That's obviously what it means. Second, payment of creditors. Payment of the debts due by me to my creditors as at the date I signed this trust deed. Payment to my creditors should be made in accordance with the order of priority and distribution provided for in section 51, etc. There are a few more lines at the end to which I shall return later. And then third, payment of surplus. My trustee shall hold just count and reckoning with me, and after making payment in implement of clauses 1st and 2nd above, shall reconvey to me such of my estate as he may not have realised, and shall pay to me any remaining surplus. And what I say, my lord, about that is that it is impossible to read these provisions without concluding that not a farthing is to revert to the debtor unless and until the creditors have been paid in full. That's what the order of priority is there for. I pause to say that in reality, nobody expects the creditor to be paid in full, because indeed the very first words of the trust deed say, I, with the name, because I am presently unable to pay all of my creditors.
Should that mean that it's wholly unlikely that creditors will be paid in full? It may just be a cash flow problem.
Well, it's thinkable in principle, my lord, but the reality is, if one looks at how these things work in practice, I think one would struggle to find an example of a trust deed where there is actually a surplus for the creditor. Then I think things may have been different in the 19th century when surpluses did emerge, but these days...
We all thought that before the Lehman insolvency.
Well, yes,
Were we wrong?
Well, I can see that, my lord, I can see that. But in fact, the point is this. Let us say that this turns out, contrary to what the debtor himself imagined, that there is going to be a surplus. Well, that's fine. I say that under clause 7, we can see that if, but only if there is a surplus, it goes to him. That's really the point I wish to make. And one can find that, underlined by the words in clause 7, third, after making payment in implement of clauses 1st and 2nd. So once again, that underlines the question of priority. Now, there are words at the end of clause 7 second, which I must take to court. It's just the last couple of lines. My trustee shall determine, as he thinks fit, the times when payment should be made, what notice of payment should be given, and whether payment should be made by way of interim or final dividends. Now, I take the court to these words because the reference to the trustees determining, as he sees fit, whether there should be an interim or final dividends, has been taken in the courts below to signify that the trustee has power by pronouncing that, by identifying a payment as a final dividend or a final distribution, to put an end to the trust. And I say, or we say, my lords, that that is not what the intended purpose here is. First of all, one looks at where these words are situated. They belong to a small group of words which are concerned purely with day-to-day administrative matters. My trustee shall determine things, the times when payments should be made. That's pure administration. Determine what notice a payment should be given. That's pure administration. And then tucked at the end, whether payments should be made by way of interim or final dividends. And we say that all that that means is that, as with other administrative matters, if the trustee does his sums and see that he has a fund, he can decide for himself whether to pay an interim dividend on the basis of the fund he has, or whether to wait until he's ingathered more money. We say it doesn't mean more than that, and we say in particular an interpretation of this reference to a final dividend which completely subverts the order of priority established here cannot be right. One thinks almost of Shoe Lane parking, with Lord Denning saying, if that's what this is supposed to mean, one would expect a red hand to be printed in the margin to draw the reader's attention to it. And just to labour this point a little bit more, this, in our submission, this is the central clause of the trust deed after the vesting clause, because if one asks oneself, what would the trust deed do without clause 7? It would be pointless. Clause 7 is exactly what the trust is about. Now, turning now to the end of the life of the trust, we have clause 10, which links the discharge of the debtor from his debts to the termination of the trust deed, and clause 11, which provides how the trust is to terminate. And clause 11 has got 3 parts. We're not concerned with Roman 1, an award of sequestration. We're not concerned with Roman 3, the acceptance of any, by my creditors, of any composition offered by me. There's no suggestion of that. We're concerned with Roman 2, the final distribution of my estate, which for the avoidance of doubt shall include a nil distribution by my trustee in accordance with this trust deed. And we say, my lord, that when the trust deed says final distribution, it means that. It means what it literally says, what the words on the paper say, not what my trustee thinks rightly or wrongly to be the final distribution. If that's what the trust deed was intended to say, it could have said it. And indeed, one has an example of different language in clause 10 Roman 1, which is concerned with the discharge of the debtor. This trust deed is granted by me on condition that the creditor succeeding to the trust deed shall discharge me of all my debts due to them on the termination of this trust deed, unless Roman 1, my trustee, reports that in his opinion I have not made fair and full surrender. So we've got there wording which shows that the draftsman has applied his mind to a matter which is for the subjective opinion, no doubt the informed opinion of the trustee, and one notes the absence of any such words in 11 Roman 2. So we rely on the literal wording of 11 Roman 2, and we rely also on general considerations of commercial common sense, because the contention for which the respondent made by the respondent amounts to this, that in circumstances such as we have here, where on the one hand the creditors have received only 22.41 pence in the pound, and on the other hand we know for a fact that there was vested in the trustee on day 1 an asset which now exists in the form of cash. It's tucked away in a bank account. There exists an asset which has not been distributed to the creditors, even though it forms part of the trust estate. The appellant's position is that nevertheless, because the trustee in his declaration of distribution called it a final distribution, that means that the debtor now has a windfall of these monies, of which, as I've said, we know that they've always been part of the trust estate. And we say that it flies not only in the face of common sense, we say it flies in the face of the central provisions of Clause 7 and subverts Clause 7. Now, as it happens, as your lordships and your ladyship will have seen looking at the authorities, there is authority on this precise point in a slightly different but nevertheless relevant context, and that is White. But I would like to touch upon something else before coming to that. I mentioned earlier the simple nature of this trust deed and the fact that it doesn't cover everything. In our submission, this trust deed, when one looks at the wording of 11 Roman 2, simply does not contemplate the possibility that the trustee has got it wrong, because in the day-to-day cases, one just doesn't expect it to happen. The trustee receives from the debtor a list of his assets. He sets about realizing them. He pays them out. That's the end of the matter. People go about their business. They don't spend years afterwards agonizing about whether there's something else. The standard case is that it's the final distribution. So the trust deed has not made specific provision for what is to happen otherwise. But in fact, one can find elsewhere within the trust deed ways of getting around it. And it's really the notion of a compromise. We have under 11 Roman 3, the trust deed ending. I pause to say I'm not quite sure how the trust deed is supposed to come to an end as a piece of paper with words printed on, but no doubt it means that the trust comes to an end. On the acceptance by my creditors of any composition offered by me. So one possibility is for the debtor himself to say, or perhaps to ask the trustee to say on behalf to the creditors, there's a distribution being made. There exists the theoretical possibility that without anyone knowing it, there are other assets which should have been distributed, but my proposal is you take this in full and final settlement. We could leave the debtor out of account altogether. The trustee, under the powers conferred upon him earlier on in the trust deed, the general management powers, can make exactly the same proposal to the creditor, if he's sufficiently concerned. He can say, I think I've got everything in. There's always the latent danger that there's an asset vested in me that I don't know about. I'm not suggesting that the debtor is cheating. There's no one suggesting he was cheating in this case. These things happen. But what I'm proposing is that you should just take what I've got right now in full and final settlement. We all walk away. And the point I'm making here, my lord, is that that deals with the question, well, how are we ever to know that the trust has come to an end? There's a simple mechanism latent within the trust deed itself, waiting to be brought to life. And so, my lords, as far as the interpretation of the trust deed is concerned, we say that we seek an interpretation which relies upon the literal meaning of the words used in 11 Roman 2 and doesn't create any problems which cannot be resolved within the four walls of the trust deed. And we contrast that with the position of the respondent, which we say subverts the central purpose of the trust deed.
The argument that obviously is made against you is that Clause 11 envisages three possible events.
Yes.
And the first and second are clearly identifiable events.
Yes.
On your argument, the first and third
Yes.
are clearly identifiable events. The second isn't, because anything that appears to be a final distribution may turn out not to.
Well, what I say about that, my lord, is that the task of interpreting the trust deed is not an abstract exercise in epistemology and in wrestling with the question whether we know what we think we know or we only think we know what we know, etc. It's got to work in the real world. And when we say in the real world, there's almost never a problem. It is just there is a final distribution, which actually is the final distribution. people go about their business, and the solution which I have proposed, if there is a problem, is to say, if anyone's in doubt, let there be a compromise so that whatever has been distributed is taken as full and final contribution. The other point I make, my lord, I've made it in different ways, is that, of course, the final distribution has to be in accordance with this trust deed. And we say, of course, that a final distribution, which is not a final distribution, because there are assets remaining, vested assets remaining to be distributed, cannot be in accordance with the trust deed. It flies in the face of Clause 7.
Simply because it calls itself a final distribution doesn't necessarily make it so.
Well, that's exactly the point, my lord, yes. That's exactly the point. And that takes me, in fact, now, that concludes this chapter, unless the court wishes to hear more from me on that introductory
Well, can I just
section.
ask, in relation to 11.3,
Yes.
I mean, if there is a composition, that's a contract between the creditors and the debtor, and if the contract were entered into under essential error, it would be capable of being reduced.
Yes. Yes. I shall try to come to that at the very end of my submission, my lord, yes.
Will you be dealing with the question of acquirenda in your response to the respondent?
Well, my lord, I had planned, before noticing the way in which the batting order is set out in the leaflet for counsel here, which splits what I thought was my 1.5 hours into 1 hour plus 30 minutes, I had planned to deal with that as part of my
Deal with it when you wish to.
I'm obliged, my lord, yes.
So you're not bound by how the time you're given is divided up on the sheet. No. It's up to you how you divide it.
I'm obliged, my lord, yes.
Preemptive or reactive?
Yes.
Well, what I propose to do now, if the court is content for me to move on, is to look at the authorities. And of course, the first one I shall be looking at is White. But before looking at it for what it says in substance, there is the question, which I think will be raised by my learned friend, whether it makes any sense for the court, when looking at a trust deed for creditors, which is a private trust deed, to look at case law on the insolvency legislation. And we say it makes eminent sense because if one strips aside all the trappings and details, they're both about the same thing. They're essentially about a debtor whose estate is transferred either voluntarily or in a compulsory manner to a trustee for the benefit of creditors, in other words, to be distributed as far as it will go among creditors, on the understanding that there will come a time when the debtor himself is discharged of his personal liability. So there's something in it for everybody. If I'm the debtor, there'll come a time when I'm discharged. And the creditors know that although there will come a time, probably, to come back to my Lord Briggs' question, probably when they haven't been paid in full, they accept that that's it. That is as good as it's going to get from their point of view. Now we say those elements are present in the insolvency legislation, whether it's to do with companies, whether it's to do with winding up, company voluntary arrangements, individual voluntary arrangements in England, though we don't have them in Scotland, or trust deeds. And one has, in fact, the Earl of Selborne in White saying just that. If I could take the court to White, it begins at memory stick, as I now call it, page 555.
Can I just ask you one question about
yes.
legislation while it's in my mind?
Yes.
And it's just for information.
Yes.
This is a protected trust
Yes.
within the meaning of
Yes.
Schedule 5
Yes.
To the Bankruptcy Act. You've put in the bundle the 2008 regulations,
Yes.
which allow the sheriff a very wide power to make orders in respect of protected trust deeds.
Yes.
What I'm wondering is whether those 2008 regulations apply to the trust deed that we are dealing with here.
Well, that's a very, Lord, fortunately for the court, my time is limited, because if I were to address that question fully, I'm involved in another case right now, my lord, in which precisely that point arises, because if one looks at the 2008 regulations, it's clear that they don't apply to anything that occurred before the date in which those regulations come into force. Right. And then one looks at the 2013 regulations, and one sees that they equally don't apply to anything which came into force before, but they do preserve the 2008 regulations. And perversely, rather than saying that the 2008 regulations are kept in force with respect to the period to which they originally applied, the 2013 regulations say that the 2008 regulations remain in force with respect to all trust deeds before the date of commencement of these regulations. So on one view, which is yet to be settled by the court, either accidentally or deliberately, Parliament has thrown the net backwards and captured, in those few words, with respect to the 2008 regulations, trusts which were never caught by them in the first place. I don't think it's something which this court necessarily...
Well, I'm asking because I understand that the sort of problem that we are dealing with in this case has been addressed in relation to more recent trust established.
Yes.
Well, one recently more established trust deed, and by Sheriff making an order under, I think the provision he might have been acting under was in the 2016 Act, which has now replaced the regulation.
Exactly, my lord.
I'm thinking of Sheriff Holligan.
And in fact, it's rather like the position of a, well, let's say an administrator under Schedule B1 of the Insolvency Act. The administrator can go to court at any time and seek directions, and effectively the mechanism now is for the trustee to go to the sheriff and seek directions. Yeah. And the thinking is that the sheriff can give directions which would answer, in an appropriate case, the sort of question which falls to be answered here.
But as I understand it, neither party is going to be submitting to the court that power is available in the present case.
No. I think we've come too far for me to suggest that this court hasn't got jurisdiction. It's too late in the day.
You've submitted to it already.
Now, I don't know if I can assist my lord in the chair any further.
No, that's very helpful, thank you.
So I was about to say that the point that cases under the insolvency legislation are of sufficiently general application to be material to considerations before the court here, the point is made, at least indirectly, by the Earl of Selborne in the White case. And although I took the court to the first page, if the court looks at page 559, we have, just a few inches down, first of all, Lord Selborne saying what he thinks this case is about. Well, the case, as I understand it, rests upon this proposition that when a trustee has been discharged under the 152nd section of that's the 1856 Act, all funds at that time distributable in the bankruptcy, of course I put the case of fraud aside, and which have not at that time been distributed, vest by law in the bankrupt for his own benefit, although the creditors have not been paid 20 shillings in the pound or interest on their debt. So that's how he summarizes what the case is about. And then in the middle of the page, having said, I confess, my lord, I have great difficulty in following that argument, he says, having regard to the express provisions of the Act as well as the general purpose for which it is passed. The general purpose is to enable a debtor who cannot pay his way to get discharged upon the footing of giving up the whole of his property and to distribute that property as far as it will go among the creditors. And we say, well, that's exactly the position here. And that is why there's really no serious room for the proposition that it's inappropriate to look at a bankruptcy case when the general purpose is exactly the same. Indeed, I think it's probably recognized on both sides that granting a trust deed for someone who's in difficulties is simply an alternative to in Scotland, it's an alternative to bankruptcy. In England, it might be an alternative to having an IVA. But it's an alternative to bankruptcy, and it shares many of the same Now, the point, of course, about White, and the point to which I wish to take the case, is that the court was concerned with the meaning of the expression final distribution in the context of the Bankruptcy Scotland Act of 1856, and really rely in particular upon the words of Lord Watson, which appear in this bundle on pages 561 to 562. And perhaps I begin with the introductory words. He's agreeing, his lordship here is agreeing with the Earl of Selborne. My lords, I'm of the same opinion. The provisions of the Bankruptcy Act of 1856 strip the bankrupt of the whole property of every description which is vested in him at the date of the sequestration, and also of all property that may come to him during the subsistence of the sequestration prior to his own discharge. According to my view of the statute, he can only get back the property which has been taken from him absolutely and irredeemably by the force of the statute in one of three ways: either first by his discharge under payment of a composition to his creditors, secondly by receiving a part of it as surplus after satisfying their claims to the extent of 20 shillings in the pound, or in the first place by a transaction with the trustee and the creditors. And then we have more wording there. But looking at the bottom of the page, now as to the period when a sequestration comes to an end, the able argument of Mr. Haldane rests mainly upon this, that this sequestration, the sequestration in this case, had absolutely come to a close in terms of the statute, and accordingly that the exercise of their praetorial power by the First Division of the Court of Session, which was in reality legislation, etc. And then jumping a few lines, I think the final close of the sequestration contemplated by the statute was the discharge of the trustee after the final distribution, after the whole of the funds vested in him by force of the statute had been applied to their proper purpose, namely payment of the debts ranked in the sequestration. When I speak of final distribution, I mean distribution of what were, in fact, the last funds available for this purpose. And we rely on that, my lords, and we say that applies precisely here. Perhaps by way of explanation, I should have mentioned the reason why the court here is talking about the 1856 Act at all. No, I
mean, the problem, the problem here was that the trustee appointed under the legislation
yes.
had been discharged.
Yes.
And so the remedy being sought on the discovery
yes.
of undistributed assets
yes.
was the appointment of a new trustee.
Yes, yes.
Yeah.
That's exactly right, my lord. I think my learned friend is going to suggest to the court that that makes a difference. I say it makes no difference because regardless of how the question came to be before the court, the question itself, which the court fell to determine, is precisely the question before this court today. In this insolvency context, with the purpose of the 1856 Act on the one hand and the purpose of the trust deed on the other hand, how does one answer the question, what is the meaning of final distribution? And not only do we rely upon Lord Watson, but we ask the rhetorical question, what earthly point would there be in holding that this expression means one thing in the context of the insolvency legislation, and another thing in the context of a trust deed which, in its general thrust, is intended to mimic the insolvency legislation? We say it makes no sense.
And the discharge in that case had been the result of simply the passage of time.
I'm not quite sure how the discharge got. We've had a look at the 1856 Act, but we haven't discovered anything in it which assists. I'm looking at the Act again in another context very shortly.
Yeah, I mean, Lord President's quoted at MS 557 towards the top of the page, saying that all that's required to sustain such an application in circumstances similar to the present is that it should be averred that there are funds
yes.
belonging to the sequestrated estate. The bankrupt has been discharged not upon a composition, but only by reason of efflux of time or by the consent of the creditors, and petitioners shall be creditors who have not been paid in full.
Yes. I shall be coming to the question of effluxion of time in a rather different context, and that's the Section 32 context, which was mentioned, which was trailed, so to speak, by my Lord Hodge a few minutes ago.
Yes, the period between the sequestration and the discharge was only, I think, 21 months.
Yes.
According to the facts at the beginning of the case.
That leads me to look ahead very briefly for almost literally a couple of seconds at the question of reduction, simply to notice that the longer the period which has occurred, the longer the period of time which has elapsed, the greater is the difficulty of achieving reduction as a remedy. Yeah. What I've been going to do, if the court is content for me to do so, is to move on now to look at Mond which is the case principally relied upon against us by... But before I move on, my learned friend has pointed out that what the Lord President is doing in the passage to which my Lord in the Chair has drawn my attention is that he's drawing a distinction between composition on the one hand and what we have on the other hand. And of course we say here there is no composition. Yeah. If there were, we would have seen it. It's as simple as that.
It does look, doesn't it, from page 562, paragraph starting now in this case, in Lord Watson's.
Yes. Yes.
That there wouldn't have been a discharge by effluxion of time.
No.
If anybody had appreciated there were still available funds.
That's exactly it, my Lord. Yes.
Yes, so it may simply be the trust that the creditors had voluntarily granted the trustee his discharge.
Yes.
Under this
well,
apprehension.
yes. As a matter of fact, my Lord, we have with us the session papers in Flesh and Mustard. I'm not see whether there's time to refer to them, but they make very, very detailed provisions for the trustee to give a certificate in quite precise and rather lengthy terms, referring to the bringing about, creating actually, it's a performative utterance in a way, creating the discharge of the debtor.
Yes, the reading on in paragraph or Briggs referred to, it must have been a voluntary discharge by the creditors, which he says was either in ignorance or by inadvertence.
Yes, that must be right, my Lord.
When a trustee, he goes on, has been discharged upon that footing erroneously, I don't doubt, indeed I think it's implied in the statute, that the court has power to furnish the machinery necessary for working the sequestration to its purpose.
That takes us back to the technical question which is before the court in that case, which was, has the court got power at all to reappoint the trustee?
Yeah. So the analogous question in this case would be whether the court has the power in those circumstances where the trust deed is where you're dealing not with a statutory sequestration but a voluntary trust deed, but again there's been a discharge erroneously granted on the footing that there had been a final distribution when in fact there hadn't.
I should be saying, of course, when I come to the Scottish Law Commission on that subject, that of course, from our point of view, we don't get to that question at all if the court is with us on our primary submission.
Do we have Section 152 of the 1856 Bankruptcy Scotland Act?
I'm afraid I don't. I'm the only section to which I was going to refer in another case, my lady, is Section 65, because it's, well, we have it here.
Oh, right. Thank you. Thanks very much. Thank you.
If I may take the court now to Mond. This is a case, it commences at page 503 of the bundle, some of these cases are dealt with at a high level of abstraction, but this is a case where the facts themselves are rather important. And indeed, the 1856 Act, this is a case where the respondents, a partnership, granted security over shares to the people who now became the reclaimers. And of course, as the Scottish judges here will be aware, the only way in which one can grant security over shares in Scotland is for the secured creditor to have his name entered in the register of members in respect of those shares. We have no notion of an equitable security in Scotland. So the secured creditor goes on the register. And that's what happened here. And then the respondents granted a trust deed for their creditors, which incorporated, so far as material, the provisions of the Bankruptcy Scotland 1856. And the consequence of that is there was also incorporated Section 65 of the 1856 Act. Now, that is set out at the foot of page 504, but in fact, these are very familiar provisions in an insolvency context. We have them still in force today. And these are provisions which simply say that if in a bankruptcy a creditor holds security, he must value the security. And when the creditor has valued the security, the trustee has a choice. He can say, if that's the value you put on the security, I'm going to purchase it from you at that price. You have the money, you can then claim, you can prove for the balance. Or, I'm not interested in taking the security subject from you, I'm going to leave them in your hand and you still claim for the balance. And what is clear in this case, reasonably clear, is that the trustee took the latter course. He never took title to the shares, he left them in the hands of the secured creditor. Now, in due course, the trustee granted a certificate stating that the estate of the respondents had been realized and a final division had been made. We get a summary of the certificate on page 505, and then the respondents, that's the firm that originally had granted the security, sued the reclaimers, the secured creditors, for an accounting of the manner in which they had dealt with the shares. Now, the secured creditors advanced a number of arguments, many of which are really not worth spending time on. But the key argument was that the original firm granting security had no title to sue. And this is what Lord Traynor made in holding for the respondents, that's to say the debtor who granted the security. He says this at page 509. The defender's right was originally a right of security, and nothing has happened which could convert that right into a right of property. The fact that the trustee did not take over the security at the defender's valuation did not change its character, it simply left it as it was. The right, as a security right, was reserved, that's the word in the statute, of course, to the defenders, and they will now get the full benefit to which it entitles them. The only point debated which seemed to me to call for attention was this, that the right to the reversion now claimed by the pursuers was or might be a right which the trustee was bound to vindicate in the interest of other creditors. But to this the answer seems conclusive, that no one has now any interest except the pursuers. Under the trust deed to which the pursuers' creditors acceded, it was made matter of contract that on receiving a final dividend as declared by the trustee, the pursuers should ipso facto stand discharged of all claims ranked on their estate. Such a dividend has been paid, and the discharge given. In my opinion, that operates practically as a discharge on a composition would have done, and had the effect of reinvesting the pursuers. They accordingly have the sole right to any part of the estate held by the defenders after the defenders have operated out of the security subjects payment of the balance of their debt, to operate which alone the security was given to them by the pursuers, and, he adds this, and left with them by the pursuers' trustee. So, the significance of those last words left with them by the pursuer's trustee emerges if one looks at what Lord Kincarny says. Lord Kincarny's judgment is lengthier and more detailed. And if I could take the court to page 510, about 2/3 of the way down the page, the first, second, third paragraph, the last 3 lines say this: the record is not quite distinct on the point, but I understand that the trustees did not demand any assignation of their securities, and that none were granted, but that the defenders were ranked for the balance only. And then halfway through the next paragraph, counting 2, 4, 6, 8 lines down, the trustee could not divide these shares which he had not purchased. The question, therefore, in this case is who had right to these shares. There's no question here with the trustee, but I think it clear that the trustee has no right to these securities. He might have had them when they were valued if he had chosen, and he might have demanded an assignation of them. But if he did so, he would, under Section 65, have required to pay the value put on them by the defenders. Not having done so, it's impossible that you should claim them now as in he does not. So that's twice that we have this Section 65 point mentioned. And now we have, the third time, failing an assignation demanded and paid for, the provisions of the 65 section that the full benefit of the securities tendered by the creditor is reserved to the creditor appear to apply, and that accordingly the benefit of these securities is reserved to the present defenders. But the nature of their rights is not altered. Their right is only reserved. It was a right in security and remains so. Nothing happened which could alter its quality, but the radical and proprietary right, being neither in the trustee nor in the creditor, must of necessity remain as it always was in the debtor. Now, I start by asking the question, why, in this still relatively short judgment, does Lord Kincarny find it necessary to mention 3 times that the trustee did not exercise the right conferred upon him by Section 65 to purchase the shares? It must be because it makes a difference to the outcome of the case. And in my submission, it does, because clearly the unspoken message from Lord Kincarny is that if the trustee had exercised his statutory right to acquire these shares, he would now be on the register, they would be vested in him, they would be part of the trust estate, and that would be determinative. And so we take from that, my lord, 2 things. First of all, that very question, what would have happened if the trustee had taken title to the shares, is not specifically addressed by the court in Mond at all, because it wasn't what the court was looking at. What the court was looking at was a dispute between 2 parties, the grantor of the security and the grantee, a dispute to which the trustee was not a party, and therefore to that extent, what the court had to say about the trustee's position was a purely obiter. But in my submission, to labour the point a little, one cannot read Lord Kincarny without concluding that it is implicit in what he says that if title had been taken to the shares, the outcome would have been different because title would have been in the trustee. And we say, therefore, that the factual position in Mond is diametrically opposed to the position in today's appeal. In Mond, the shares never vested in the trustee, whereas in today's case, there's no doubt that the right to compensation vested on day 1 by virtue of the cross-reference in the trust deed to Section 31 of the 1985 Act.
I understand that the shares didn't vest in the trustee, in the sense that the legal title to the shares didn't vest. Does Scottish law comprehend an equity of redemption as being a separate piece of property, which one would have thought was in the debtor and then the trustee throughout?
Well, there is an aspect to this Mond case which is inherently unsatisfactory, even on the terms in which the judgments are expressed, because what one doesn't see in the judgment at all is any reference to the vesting clause of the trust deed. Now, we have the session papers. I could take the court to them if necessary, but what I can tell the court is that the vesting clause, well, I can see my Lord Hodge reaching for it, so perhaps I should do likewise.
If what you are looking for isn't there, then...
Well, it is there, my Lord.
It is there.
Yes. Unfortunately, what has been produced, of course, doesn't have the continuous numbering of the other document. The closed record begins on the title page. It goes on for a few pages, and then we have, after page 11, we go on to the joint print of document for the parties. We go on, joint print of document for the parties, and the first of the documents is the trust deed, and that is reproduced on page 3 of the joint print. And looking at that first paragraph and reading it on stilts, jumping from word to word, we have 1, 2, 3, 5 lines down, we, then a few lines further, do hereby dispone, assign, etc., over in favour of Daniel McIntyre, etc. A few lines later, all and sundry, and then we have a recital of various assets. And then, and all other funds, estates, and effects, heritable and movable, real and personal, of whatever kind or denomination, and wheresoever situated, present belonging or indebted to us. And then a few lines further down, or to which we or any of us have right or title, or in which we or any of us are interested in any way. Now, I say that those words there are capable of carrying the equity of redemption in the shares.
Yes. So there is such a thing as a...
Yeah, absolutely, my Lord. Yes. I mean, we fight shy of English terminology in Scotland, my Lord, for reasons which take up even more time. But there is an...
Fight shy is one way of putting it.
But there is an equity of redemption. What we say, as a matter of fact, these words did carry the equity of redemption, and the problem, of course, for the trustee is that if he hasn't had the shares himself vested in him, the mechanics of realising the equity of redemption present a problem, because the way to realise the equity is to sell the shares,
Yes.
and he can't do that because he hadn't got them. So we say, my Lord, that although Mond Luke is relied upon by the appellant as by the respondent rather, as against us, in fact, it doesn't deal with precisely the point with which we are concerned today, save in an obiter manner. Now, I then turn to the third and last of the authorities to which I wish to take the court, and that is Flett and Mustard. That's at page 451. And not much information is given, but the head note says that the discharge of the debtor under a trustee, the trustee discovered that the property that had vested in him included a claim against a foreign bank for rubles deposited and so on. And we rely upon this case as authority with the proposition that in the absence of a composition, the trust estate cannot revest in the debtor. And that's set out in the statement of case for the appellant at paragraph 4.2. It's on page 0.59 of the core bundle. I needn't take the case to that. What we do rely upon is, in particular, what Lord Norman, the Lord President, said at page 458 of the bundle, in the middle of the page. He says this: there is, however, in these cases, nothing which affects the principle that a trust deed is a deed granted for the purpose of vesting the whole estate in the trustee and of satisfying the creditor's debts out of the whole estate, so far as its value and extent allow, and that there can be no retrocession until full satisfaction has been made, unless the creditors consent to abandon some portion of it, or unless a discharge on composition is granted. A discharge on composition, not simply a discharge. On composition. A discharge without composition does not terminate the process of distribution, which may continue for years after the discharge is granted. Now, we say that the essential point here is that the mere fact that the debtor has been discharged doesn't mean that this as yet undistributed part of the estate revests in him because there has been no composition. I should perhaps mention in passing that at page 459 we have his lordship repeating. This is he says this is the top of page that page, going down, talking about the discharge. Last few lines. It neither brings the trust to an end nor does it reinvest the debtor in his estate. Now, it just so happens that in this trust deed, the way it's drafted, the bringing to the end of the trustee of the trust and the discharge of the creditor are brought together, but in fact, conceptually, they're quite different notions. But before leaving this case, my Lord, I should draw the court's attention to what Lord Moncrieff says about the case of Kinmont Luke, to which I was referring a few moments ago. We find Lord Moncrieff, in particular at page 460, where we find his name towards the foot of page 459. In the course of the next page, he discusses a case called Geddes and then Kinmont Luke. He notes that Lord Traynor and Lord Kincarney decided Kinmont Luke on different grounds, and then at the very foot of page 278, he says, any further observations as to whether, in these circumstances, as the result of the trustee having lost his right to demand an assignation, the creditors have lost their right to claim the asset, were not only entirely obiter, but were made by the learned judges in the absence of any representation on behalf of the creditors or of the trustee. All that was decided was that, in the absence of the trustee, the right of the bankrupt was preferable to the only right asserted against him, being a right asserted by the secured creditor to have the security subject translated into the subject property. And then a few lines down in the concluding paragraph, neither of the cases, that's Geddes and Kinmont, determined the only question which is here in issue, videlicet, whether, notwithstanding the discharge of the insolvent in such a general form, his creditors may still assert, whether by direct action or through the trustee, their continuing right to claim what had previously passed from the insolvent to a trustee appointed to act on their behalf. Now, I anticipate that my learned friend will say that it makes a difference in Flett that there's talking of the creditors having a right, but in my submission it makes no difference at all. The point is the same. There's been no composition. There cannot be a revesting. Now, that really concludes what I was planning to say about the authorities. These are the ones which really go to the nub of the matter today, and I would therefore propose to move on to what I have to say about the case for the respondent.
But you might have to bear in mind that you are very shortly going to be eating into your reply time.
My Lord, I had a whisper in my right ear which has drawn my attention to that very fact. Now, the respondents naturally rely very strongly upon Kinmont. I've dealt with that. But there is a point which they make twice, in fact, and that is that according to the interpretation of the trust deed for which we contend, it must follow that the trust deed will go on and on and on, possibly forever, or at least until somebody dies, until the debts of the debtor as owed to the creditors on day one are discharged in full. And one takes that, for example, from pages 66 and 67 of the bundle, where we have the case for the respondent. At the foot of page 66, the appellant is arguing the trust deed has not been terminated. The consequences are that Mr. Davidson has not yet become entitled to a discharge, and that his income, clause 2, and estate that he acquired, clause 1, continue to fall into his insolvency. What is more, that will continue to be the case even if the appellant receives the PPI compensation of about £56,000, because Mr. Davidson's net debt is £73,000. He is exposed to indeterminate insolvency until his debts, including expenses, etc., are paid in full. And then one has that same argument revisited at paragraph 17, which is on page 017. The approach of the appellant leaves Mr. Davidson condemned to the common law state of indeterminate insolvency at the mercy of his creditors. This is almost Dickensian at this stage, I have to say, at the mercy of his creditors until payment in full.
We have the argument, but we'd be keen to hear your answer.
Yes, well, the point is this, my lord. We say that that proceeds upon a misunderstanding of how the incorporation by reference of Section 32 of the 1985 Act works when seen within the wording of the trust deed itself. And that takes us, therefore, to the vesting clause, which is on page 241. If the court has that, I, reading short, because I am presently unable to pay all of my debtors, transfer to, reading short, my trustee, I'm on the last two lines now, the rights and assets which would vest in a permanent trustee in terms of sections 31, 32 and 33 of the, reading short, 1985 Act. Now, section 31 is the section which takes a snapshot of the bankrupt's asset on the date of sequestration and says those assets vest in the trustee. Section 33 is the section which excludes certain matters from vesting, starting most obviously with estate which the debtor holds in trust for somebody else. And Section 32 is concerned with what Scots lawyers in their dog Latin called acquirenda, but which might, in a more user-friendly way, be called after-acquired property. And Section 32 is set out in the authorities. It's the very...
MS 375.
Yes, I'm obliged, my lord. In fact, before even looking at it, I'll tell the court where I'm going. The point is, in a nutshell, is this, that because of the wording of the vesting clause in the trust deed, we must ask ourselves, in order to identify the after-acquired property in question, we must ask this question: what is the property which would vest, not might vest, which would vest in the trustee under Section 32? And the short answer is it would have to be property which fell into the estate no later than the third anniversary of the date of sequestration. Now, Section 32 begins with subsection 1, the trustee, the debtor keeping his income. Subsection 2 then allows the sheriff to give some of that to the trustee. Of concern to us is subsection 6, which is on pages 376 and 377. Without prejudice to subsection 1, that's the income clause, any estate, whatever situated, which A, is acquired by the debtor on a relevant date, and B, would have vested in the permanent trustee if it had been part of the debtor's estate on the date of sequestration, shall vest in the permanent trustee. It goes on with some exceptions with which I need not take up the court's time. The key thing here is that vesting will not occur at all unless it occurs on a relevant date. And if we ask, as we must, what is a relevant date, the answer is over the page in subsection 10. In this section, a relevant date means a date after the date of sequestration and before the date on which the debtor's discharge becomes effective. So we now ask ourselves, well, what is that date? And the answer once more is over the page in section 54, which is rather conveniently headed automatic discharge after 3 years. And subsection 1, this is page 380, says, subject to the following provisions of this section, the debtor shall be discharged on the expiry of 3 years from the date of sequestration. Now, that's followed by provisions which allow the sheriff, on the application of a trustee or any creditor, to defer the date of discharge. But the simple point here is that the statute says nothing about conferring a right upon a trustee under a trust deed to apply to the sheriff at all to defer the date of discharge. The only possible date of discharge is the default date of 3 years under section 54(1). There's no mechanism to extend it in this case. So if one goes back to the question, looking at... I'm sorry, my lord.
Well, the trust deed doesn't contain any reference to section 54, but it does provide for the discharge of the debtor in clause 10.
Yes. Well, with respect, my lord, your lordship, it's important not to get one's analytical lines crossed, if I may put it like that, because the nature of the exercise which we are seeking to conduct under subsection 1 is not to ask ourselves when under the trust deed is this debtor discharged, but what is the property which would vest as after-acquired property under section 32 if this were a bankruptcy and if the trustee were the trustee in bankruptcy.
Well, I think I can understand the argument.
Yes. And so it's because of that that one has to look at what section 32 says. One has to look at the time frame imposed by section 32(10). One then has to look at section 54(1) to see that the default period is 3 years. And the point which I think I made before was simply this: although the trustee under a sequestration can have that extended, the trustee here can't. And therefore, the idea that after-acquired property can go on vesting is simply not consistent with the proper reading of the vesting clause in section 32. I skip briefly through one more point, my lord, and that is the income point. The suggestion is also made in the provisions of in the parts of the statement of case for the appellant, to which I've drawn the court's attention, that the trustees, the debtor's income will go on vesting in the trustee forever. Well, the relevant provisions there are clauses 2 and 3 of the...
Yes, and there's a 36-month agreed period.
Yes.
Thereafter, the income belongs to the debtor.
Yes, it's simple as that. And that, even if there were no agreed period, the position would be that Clause 2 speaks of any contribution I may be required. Clause 3 says that my trustee is entitled to receive payment from me, but it envisages an agreement, and failing agreement, and a decision by the sheriff. So in reality, first of all, a given debtor may have next to no income, so the question doesn't arise. He may be on benefits. The question of trying to take his benefits from him won't arise. The trustee may never call for a contribution. If the trustee does call for a contribution, there may be some agreement that after all the contribution is not going to be made. And in any event, if there's an appeal to the sheriff might also decide that there's no contribution. So there's no certainty at all here that a contribution will be made. And what has happened in this case, in fact, is that the trustee has agreed with this creditor that the creditor will make monthly payments for 36 months, I beg the court's pardon. And one takes that from the circular letter of 16 September 2010, which is at page 258 under the heading contributions. The 36 months have come and gone. And therefore, this particular tract of the respondent's argument is really, if it's about anything at all, it's about what the French call le sexe des anges. It's about something rather abstract, which has no real practical effect in this case. I'm with one eye to my watch. I should turn now, if I may, to the points raised about the Scottish Law Commission in its discussion paper and its report. What I say is this: if one looks at those documents together, what one sees is that the principal thrust of what the Scottish Law Commission is about is identifying what it is that the law of Scotland might come to be if certain legislation is enacted.
But it also, I mean, we referred you to it because it was a convenient way of drawing your attention to authorities as to what the Scottish law currently is.
Exactly, my lord. Well, that comes to my next point. The point is that in suggesting what the law might come to be, the Commission naturally takes a snapshot of what the law is, and it's that snapshot that is important. Now, there are really only two cases here which are, in my submission, which are worth looking at. One is Dundee General Hospital and Hunter, and one finds these summarised in the
I wonder if perhaps the other cases, the Hunter case, may not be more directly relevant.
The Hunter case is in fact the case in point, because the problem with Dundee General Hospital, as indeed...
Yeah, that's the exercise of discretionary power.
Well, that's right. It's about discretionary powers, and also one can see that the challenge is exactly... The heads of challenge are exactly what one would expect to be. If this were administrative law, they all look familiar. And the problem is we're just not in that territory.
Yes, whereas Hunter is dealing with the effect of essential error.
That's right. And so that's why Hunter is the case in point. And Hunter is dealt with... of course, I've looked at Hunter, but what I take from it is that, in fact, the substance of Hunter, for present purposes, is in paragraph 19.22 of the report.
Now, I'm not sure that all members of the court have a copy of it.
I can read out the sections.
Right, that may help you.
It's on the page numbering from the report is page 254, taking numbers from the bottom of the page. And we have first of all, Lord Reid. I can take the court straight to the very end of that paragraph. It appears to me to be reasonable and in accord with the principles of Scots law that a person should not be entitled to retain a gratuitous benefit given under essential error on the part of the person conferring the benefit. Of course, we do say in passing that's precisely what the outcome would be here if the court were to find in favour of the respondent. Now, the problem, if that's not too strong a word, is the contrast between the way in which Lord Reid has formulated this very general proposition and the more restricted manner in which it's approached by Lord Keith. He says that a gratuitous obligation entered into under a material error reasonably entertained as a ground of reduction under the law of Scotland is, I think, well settled by authority. And then a few lines down after the authorities, in the matter of gratuitous obligation entered into through error, it does not, in my opinion, matter whether the error is essential error as to the nature of the deed or an error as to some extrinsic circumstance. Material to the granting of the deed. In either case, the deed is, in my opinion, reducible. Now, of course, the words that leap off the page there are these: error as to some extrinsic circumstance, because that would be precisely the sort of error, subject to what I'm about to say, with which we are concerned in this case. The difficulty here, though, is that his lordship speaks about the granting of a deed and the incurring of a gratuitous obligation. And if we want to look at that literally, all that's happened here is that the trustee has told the creditors in writing, this is the final distribution. He hasn't granted a deed in any sense of the word. He has not, in a sense, entered into any obligation to do anything at all. So on a literal reading, even there, we aren't fully in this territory. But the difficulty in any case, which I ask the court to consider, is that there is a slight tension between the general approach of Lord Reid and the more restricted approach of Lord Keith, if the court were to ask itself, well, let's just assume that this is the sort of error as to some extrinsic circumstances which can give rise to a remedy in reduction. What would that mean in practice? Well, the first question is, who would seek the remedy? How would the creditors ever stumble again into the fact that there was a remedy there to be sought? It's interesting to note, well, it's almost interesting, perhaps I should say, to note that in this case, the only explanation for the trustees knowing about the bank's proposed payment of compensation to the debtor was that for some reason the bank's letter addressed to the debtor informing him of the compensation was sent to the trustee. But for that, the trustee would never have known about it. And so that raises the question in practice, how would anyone know that there was a remedy there waiting to be sought? But more important still and more essential to this is that, of course, whereas under the interpretation for which we contend, the matter is clear as a matter of interpretation of the trust deed, if we're to fall back on reduction, reduction, of course, is a discretionary remedy. And so if that were the only route open in the present case, looking not just at our trustee, but other trustees, we would find potentially a multiplicity of litigations with several different trustees. Each trustee would perhaps be litigating in respect of several different trustees, trust deeds rather, and each respondent or defender to litigation would turn up in court with a variety of different defences. And so the approach which consists in saying, let's just adhere to the inner house's interpretation of the trust deed, if that's what the court was thinking of doing, and leaving it to reduction as a remedy is, well, first of all, it's what I think our American cousins call kicking the can down the road, which, of course, is something which Supreme Courts have been known to do on both sides of the Atlantic, quite recently on the other side. And it simply substitutes for a position which is clear and is applicable in case after case after case. A position which will vary from case to case, will trigger litigation, and will simply replace clarity with the uncertainty of a discretionary remedy.
Yes, but if the court was not persuaded that the clarity that you seek is available in the document, yes, then what would your position be about the remedy?
Well, let me put it like this, Mond. Let me contrast the position of the trustee in the present case with what the position of another trustee might be. It just so happens, for the reasons which I explained earlier, the trustee here is sitting on the money because having received the letter from the bank, he contacted the bank and said, you send that money to me. And the money right now is sitting in a dedicated account awaiting the outcome of this litigation. So exceptionally, I think it is exceptional, this trustee actually has the funds and they can go wherever they have to go. But in other cases, it's altogether thinkable. Well, in fact, I'm doing another case for the same trustee, as a matter of fact. The debtor has taken the money. There's another case where the debtor has taken apparently £380,000 some years ago, and now says to the trustee, well, I'm afraid it's mostly all gone.
Well, you know, this is part and parcel of setting aside deeds or acts which are vitiated by error.
Yes.
You can't always do it. It's discretionary.
But,
and in contract, it depends on whether restitutio and integrum is possible or not.
I accept
Sometimes
that.
it isn't.
I must accept that, but I do say that's precisely, if that is thought of by this court as an alternative approach to the solution of today's problem, that's why I say it is a less satisfactory approach, because it simply leaves further uncertainty to be decided in the future.
I see that point, but if this were the only bit of flotsam that you could grab, then
which you're swimming away from determinedly.
how would you operate
Like a
it?
tabula in naufragio, as we sometimes call it.
I'm not, as a matter of fact, I'm not swimming away from it, because your Lordship will not be astonished to hear that this is a question which has been adumbrated on this side already as a long stop issue, so to speak. But of course, it is recognised that with the passage, well, in this case, in this particular case, there'd be no difficulty, but in other cases, the discretionary remedy and the nature of the defences which may be advanced, including the classic defence, well, it all happened ages ago and I spent the money, I can't spend it twice. These are difficulties which make that particular approach unsatisfactory from the point of view, to go back to where I started, from the point of view of the creditors in whose interest the trust deed was granted in the first place.
I'm sorry if I'm being slow, but does that amount to you aren't asking us to do anything about that alternative remedy?
Well, there is no... Well, now that your ladyship gives me a hint of...
That's not a hint of anything, it's a question. I just don't know whether what you're saying about it.
Having wrestled with the subtlety of your ladyship's question, I would say this, that if this court feels that without any mention in the pleadings thus far, that it's open to it in this...
Well, it's not.
No.
We can't grant it.
Which is precisely why I was asking you the question.
Yes.
If I'm not saying that I have reached a view, I haven't, but if there had to be, from your point of view, a fallback case, how would you go about constructing it in pleadings? Would you have any proposal in the event that your primary submission didn't work? What would you do?
If the primary submission fails, then the case would have to be this, that all the damage in this case has been done by the issuing by the trustee of a letter in which he described the impending distribution as a final distribution. And therefore, one would want to... That is the head, the cascade of consequences flow.
Well, it isn't simply the words he used in a letter.
Yes.
I mean, if the view is that he made what was properly, in legal terms, a final distribution within the meaning of the trust deed, then that was a legally significant act. And he followed it up by applying for his discharge and registering it under statute with the accountant and bankruptcy. So there are a variety of acts with legal consequences which I would have thought are valid unless and until a court sets them aside. Well,
we would have to establish every stage of the cascade, possibly including the discharge of the trustee. And of course, going back to where I started, from our point of view, the more things we have to reduce, the harder it gets for us. And so we might have to start with the letter to creditors and move along the cascade, or down the cascade, until we get to the discharge of the trustee. Although we make the point in passing in our statement of case that the true effect of a discharge, of course, is to discharge the trustee from liability. If there are any assets left, it's hard to see how one can say the trustee is discharged when he hasn't completed his job. Now, I'm looking down at my watch. I'm not determined to exhaust the last 3 minutes available to me, or exhaust anybody at all, come to that. So unless I can... I'm sorry. Yes. Well, my learned friend reminds me that quite apart from the relevance of Lord Reed's point, rather, in Hunter, the very general terms in which he expresses the principle of Scots law that a person should not be entitled to retain a gratuitous benefit given under essential error on the part of the person furnished is of itself, leaving aside what the Scottish Law Commission is discussing, a further ground for construing this trust deed in the manner for which we contend. Well, that's nibbled into my 3 minutes, my lords, a bit more, and unless I can assist the court, that would conclude my submissions, save for me to invite the court, of course, to grant the appeal.
Thank you very much. Mr. McCall, is there anything you wish to add?
There's nothing to add.
Mr. Moynihan.
Thanks, Lords. Lords and Lady, if I could just check one reference before I begin. Thank you.
I should say, Mr. Moynihan, you can take it that the court is very familiar with the arguments in your case and in the judgments below.
I'm obliged to my Lord. Lords and Lady, I will try to keep my points brief, and in response, as my Lord has said, my argument is fully set out in my written case, and indeed my principal submission is that I submit that the Inner House was correct for the reasons that they gave. And in fact, Lords and my Lady, the pivot of this decision is at paragraph 18 of the Inner House decision, in which the court looks at the two authorities. It's at page 134 in the memory stick. The court looks at two of the three cases that, as my learned friend says, are the only three cases that really concern us. Flett and Mustard, Kinmond, and of course the third is White, that I will come and look at. The court takes from the Lord President in Flett, who is in fact referring back really to the circumstances in Kinmond, that there may be circumstances in which the trust deed is to be construed as in effect a composition. And that was the conclusion that Lord Traynor reached in Kinmond. Now that is the pivot. And what is of interest is that my learned friend has said to this court that the practical solution to this dilemma about when a debtor secures a discharge under a trust deed is for the debtor and the trustee to propose a composition. Because my learned friend says there is always the risk of unknown assets. What we now sadly call the sort of Rumsfeldian dilemma. This is not a case of positive concealment. That would be fraud. The law has a simple solution to that. Parties are agreed in the statement of facts and issues. This is a case of ignorance. And can I explain to the court, without getting into the detail, there's a certain irony to the dates in this case. If one looks at the history of PPI claims, and I've not put in the court's bundle, but I can provide the copies. The seminal case on PPI is the British Banking Association decision of Mr. Justice Ousley, which was decided in April 2011. It tells us that PPI claims sort of began to gain momentum in 2006. So just as Mr. Davidson was signing his trust deed, and I haven't checked exactly the dates, but at about that time, PPI claims were coming into existence. In August 2010, the Financial Services Authority published guidance establishing certain rules, in particular, placing the onus on the financial organisation to show reasons why there had not been mis-selling, rather than on the consumer to show reasons why there had. That was August 2010. On the 8th of October 2010, the British Banking Association challenged the FSA guidance by judicial review. And that is what Mr. Justice Ousley decided in April 2011. And the citation of the case, will allow me a moment. It's at Regina, British Banking Association against the FSA, 2011, Business Law Reports, page 1531. Coming back really, 2006, Mr. Davidson is granting his trust deed, perhaps then as now, ignorant until 2014, 2015, ignorant of any possibility of a PPI claim. August 2010, the FSA issues its seminal guidance. This trustee is considering the discharge of Mr. Davidson in September 2010. So just after, immediately after that guidance was issued. And on the 8th of October, the guidance was challenged by judicial review. And the judgment did not come until the 20th of April 2011. If I would understand it, it's following the decision of Mr. Justice Ousley on the 20th of April 2011 that PPI claims in the volume that we've all now become accustomed to really began. So ignorance here is perfectly understandable if one looks at the decisions at the date on which they were being taken. We can also make another point, which it picks up the question of mistake, which I will deal with. There is also a further mistake in this case that is baffling to comprehend. The Bank of Scotland paid £55,000 in PPI compensation. The Bank of Scotland was an unsecured creditor of Mr. Davidson with a debt of £40,000. And the Bank of Scotland had received a dividend of only £10,000. In effect, the 22 pence or so in the pound. So far as this particular matter is concerned, the Bank of Scotland could have operated set-off in either of two forms recognised in Scots law, either in the form of balancing of accounts in bankruptcy, or simply in its older form, compensation. Compensation being the setting off of two liquid debts. For some reason that I cannot explain, and I do not know, the Bank of Scotland, instead of operating set-off, chose to pay the money to Mr. Mond. And of course, that then means there is available, in fact, because the bank had a debt of, it was 44, it was paid 10, so there's a debt of 34. Instead of offsetting that and paying the balance, some 21,000 over, they paid 55. And on Mr. Howland's argument, the bank now ranks only for a dividend after the payment of all the expenses incurred. And this is such an old trust that there is no scale fee, it's simply a time and line payment of expenses. There is here a series of errors that result in the particular outcome we have. Now, if I may, we look upon this case, therefore, as an historical episode. There will still, and there are still cases in which trustees overlook PPI claims, but the guidance, in particular from ICAS, is to trustees to consider PPI claims, apart from anything else, where the debtor has substantial bank borrowings, as here with Mr. Davidson, of a certain vintage. There is every likelihood that a PPI claim, a PPI policy may lie in the background. So it is now more regular for trustees to check if there's a PPI claim. In addition to that, we are here concerned in my submission with the proper interpretation of a peculiarly Scottish deed. I've made my submission, and I don't wish to go through it again, that individual voluntary arrangements in England are different. I think to pick up a point from Lord Kerr, it's not just the language of England I don't want to get into, don't want to get caught up in the technicalities of English law because I'm not qualified. This case is difficult enough. But we're also dealing with a particular type of trust, a protected trust, and of a particular vintage, 2006. The question of the period for discharge of a debtor or bankrupt, and when acquirenda is sucked in or not, has been the subject of active legislative amendment in Scotland. And I'll come to my Lord and the Chair's question about the 2008 regulations. We've had regulations, we've had amending statutes. The whole legislation has in fact been repealed, and we now have the 2016 Act, which has separate provisions relating to protected trust deeds. So it's been an area of active involvement. But this case was written, this trust deed was written against the background of the 1985 Act as amended in 1993. I mentioned the amendment in 1993, and it's covered in my written case, but if I may just explain this. Now sadly dead, the leading authority on bankruptcy in modern times in Scotland was Professor McBride. He wrote a challenging article that I will come to in 1993. He also wrote a textbook on the subject, and we've produced excerpts from the second edition, the very edition that was in force at the date when this trust deed was written. But what he explains is that the 1993 Act, which produced amendments, was intended to facilitate the use of trust deeds. As one would expect, the problem with trust deeds is that not all creditors are obliged to volunteer consent. So one has to deal with non-exceeding creditors. And the 1993 Act dealt with that by, in effect, putting instead of asking someone positively to consent, which we know said most people will not do, it's not worth their while for trivial debts. The 1993 Act inverted and said everyone is in effect bound unless they object. Now, what's important when one looks at the policy and the objective of all of this is that legislation in 1993, the scheme that we have, was intending to facilitate the use of this method of insolvency resolution. The court has that the Scottish Law Commission, prior to the 1985 Act itself, not the 1993 Act, prior to the 1985 Act, and again we see facilitating this as a simple, expeditious and cost-efficient method of insolvency resolution. And it is my submission that my learned friend is incorrect in his interpretation of Section 32, and that there would be, on his interpretation, an interminable trust deed. First of all, can I make the point I've checked, insofar as I can, as thoroughly as I can. My understanding, my lords, is that, and my lady, is that a trust deed for creditors is irrevocable because it creates rights for third parties. There is no means there for Mr. Davidson to revoke this trust deed. Secondly, he cannot escape by himself petitioning for sequestration. Paragraph 6b of Schedule 5 that the court will find at page 394 tells us in terms he cannot apply
Which provision again, please?
So, my lord, at page 394,
Yep.
it's paragraph 6b, my lord, at the foot
6b, yes, I've got that.
of Schedule 5.
Yeah, thank
The
you.
debtor may not petition for sequestration of his estate while the trust deed subsists. So if he wants to obtain an automatic discharge under a more favourable sequestration route, he cannot secure that. He is tied in. And, lords, and lady, in my respectful submission, one of the seminal points of difference between my learned friend and myself is that, of course, I accept that the purpose of a trust deed is spelt out in part by the words for creditors. It's for the benefit of creditors. But of course, the whole purpose of an insolvency regime is the quid pro quo. The debtor obtains a discharge of past debts that enables him, after the date of discharge, to start anew and acquire assets. That's the purpose. In this trust deed, the discharge and the ability to acquire assets are linked to the termination of the trust. And I won't turn it up, but I do commend to the court Professor McBride's article in 1993 that, among other things, posed the question, when does the trust end? Now, what's interesting, he posed that not just as a question for a debtor such as Mr. Davidson, but for a trustee such as Mr. Mond. When is the trustee free of any liability? Because even a discharge coming to error before even one reaches error, a discharge is construed by reference to known facts. If something is unknown, then barring the most express discharge, one would construe the discharge as not applicable to it. So when does this trust come to an end? Before we get to the interpretation provisions, the interpretation of this, The point that my learned friend has not addressed the court on is the changes that were made in the 1985 Act, reinforced in 1993, that are specific to a protected trust deed. A protected trust deed was a creature unknown in Scots law until 1985, following the report of the Scottish Law Commission, which is given to the court to see. Prior to that, trust deeds were entirely private arrangements, in other words, not publicly known. There were the problems about the rights of non-exceeding creditors and other practical issues, in particular questions about competing diligence and the rights of the trustee. Schedule 5 sets up a protected trust deed, and to be protected, the trust deed must have certain requirements, including bringing in acquirenda in terms of Section 32. But what is clear, and it's the way Professor McBride writes his book, is that the Act envisages publicity being given. It's no longer private. So the creation of a trust deed has to be published and registered. And as Professor McBride says, the end of a trust deed is regulated and it's published. And the end of a trust deed secures not just the discharge of the bankrupt, or the debtor, in fact, rather than the bankrupt, but also gives a discharge to Mr. Mond, a discharge that is not just exceeding, but non-exceeding creditors. So it answers Professor McBride's point. And pivotal to that are the granting of certificates. If I can ask the court to look, if I may, I begin and take the provisions out of order, in a sense. The court will see these begin at page 387. Paragraph 1. This relates to the means to audit the account of the trustee, so that there is some form of public check on the reasonableness of the fee. And we see that the term is used, that is used throughout this schedule, but the final distribution of the debtor's estate. Whether or not provision is made in the trust deed for auditing the trustee's accounts and for determining the method of fixing the trustee's remuneration, whether or not the trustee and the creditors have agreed on such auditing and the method of fixing remuneration, the debtor, the trustee, or any creditor may, at any time before the final distribution of the debtor's estate among the creditors, have the trustee's accounts audited. But that presupposes that there is a known date of final distribution, rather than something that floats in the ether that may change in respect of some unforeseen circumstances. And of course, the fact that the check on the reasonableness of the fee occurs before final distribution is very practical. The trustee's expenses are the first deduction. So his fee is fixed, then the balance is distributed. So one needs to know a final date of distribution. Paragraph 2 deals with diligence. It's one of the unresolved questions before this legislation. A trustee under a deed can register notice in the Register of Inhibitions and Adjudications. That secures a preference over heritable estate. So that means that other creditors can't gain priority over the trust deed by trying to record diligence. And then, of course, as Professor McBride would say in the book, when the trust deed ends, when the trust ends, Subsection 2, the trustee, after the debtor's estate has been finally distributed among his creditors or the trust deed has otherwise ceased to be operative, shall cause it to be so recorded a notice in such form as shall be prescribed as aforesaid, recalling the notice recorded under subparagraph 1 above. So the diligence is brought to an end. Now, of course, that's very practical, because that means that any, for example, lender who's approached by the bankrupt, by the debtor at some later date and asked, would you lend me £10,000, can look at the register and see the register is clear, indeed see that the register of insolvencies is clear. This is closed. The lender can then lend the £10,000. Subject to my learned friend's argument about section 54 and the suggestion that there's a 3-year limit, if this is a never open trust deed.
It might be helpful for colleagues from England and Northern Ireland to understand that when you talk about diligence, you're talking about what the English would call execution. And inhibition and adjudication are different stages in a form of execution against property.
I'm grateful. A form of security. I'm grateful to Mond.
Yes, and we're talking about heritable property, land.
Land, real estate. So a form of security that gives a priority in any ranking event, liquidation or sequestration.
It used to give a priority.
Sorry, Mark?
Inhibition used to give a priority. It doesn't anymore.
Trying to translate it into English terms exposes my ignorance in Scots terms, or the limits of my knowledge in Scots terms. But yes, it's a means of securing a degree of priority. But the point is the legislation envisages that will come to an end. And the end is final distribution. And then the key is if one goes then to paragraph 9, at page 398. Where the trustee under a protected trust deed has made the final distribution of the estates. That's the term that's in our trust deed. It's the term that's through this legislation. Among the creditors, he shall, not more than 28 days after the final distribution, send to the accountant in bankruptcy for registration in the Register of Insolvencies a statement in the prescribed form indicating how the estate was realised and distributed, and a certificate to the effect that the distribution was in accordance with the trust deed.
And we have these statutory deeds in the bundle.
Indeed. And Lords, the point that I make is that not more than 28 days after the final distribution, again assumes a determinate date. No mystery, because the trustee will be granting the certificate that the distribution was in accordance with the trust deed. He'll be granting the statement in prescribed form. It's all consistent. And the statement in prescribed form is, as one would expect, a statement indicating that he has made a final distribution of the estate. Now that is registered, it's on a public register. So again, any lender proposing to lend to someone like Mr. Davidson would check the register, would see that it's clear, would lend, and doesn't want to get sucked into his £10,000 being part of the acquirenda because there is some unknown problem with the discharge. And indeed, as my Lord and the Chair, in discussing reduction and its discretionary nature, it's exactly that type of situation where reduction becomes problematic. And reduction, in my case here, is also problematic in relation to the Bank of Scotland that made this error that they should have claimed set off. So should they really be saying the payment we made was one made in error, there's unjustified enrichment, we want to claim it back. Certainly it would be absurd to contemplate the Bank of Scotland as being the creditor seeking reduction of the discharge, because seeking reduction of the discharge just simply gets judicial confirmation of their own folly in paying this money over. There's simply a series here of errors or not, due to the fact that we're dealing with a somewhat, at this time, unusual situation.
I mean, obviously, you're making a fair point, but there are, the fact that something has gone onto a public register doesn't mean to say that it cannot be reduced. Anderson and Lambie would be a classic example. But obviously there may be circumstances which means it shouldn't be reduced.
Yeah. But that's so. Rod, if I can make then two quite separate points. In my respectful submission, there's been no submission made that the Inner House adopted a wrong approach to interpretation. Their approach was simply, how would a reasonable person in the circumstances of that time construe this deed? No problems about that. My submission is that the reasonable person would have in mind that this is a protected trust deed, subject to the regulatory controls in Schedule 5. It envisages a final distribution of the estate. And the only way I submit that paragraph 9 operates is exactly as it would have been seen by Lord Traynor in Mond, the ability of the trustee to declare a final dividend or a final distribution is indeed his decision, which, barring any reduction, is determinative. And then the practical arrangements of the Act in terms of paragraphs 1, 2 and 9 operate. And indeed it moves on in paragraph 10, page 399, to him securing his discharge. And the key in paragraph 10 is to look at, in fact, the underlining at paragraph 12. And if one then proceeds to paragraph 12, one will see that it gives objecting creditors a means to oppose discharge. So it answers Professor McBride's point. How does a trustee ever know that he is truly discharged? The answer is by following through the procedures in the Act.
Am I right in thinking there is no definition of the final distribution contained in the Act?
No, my lady, there is not. And therefore, if one will, the choice is then between, I'm very grateful to my lady in a sense to give me the turning point, the choice is between a white inheritable creditors, the House of Lords decision. It means all the estate that happens to be held, whether known or not, on the one hand, or the Mond approach, that it is based on the opinion of the trustee that all available assets have been realised. That's the choice. In relation to that choice, there are in fact 3 points that may be made. Firstly, the point I'm making, that the detailed provisions of protected trust deeds, in particular paragraph 9 that say notice must be given within 28 days of final distribution, assume the judgment of the trustee by reference to the facts as then known. A floating state of indeterminacy is not what the legislation is contemplating. That's the first point. The second is if one is looking for precedent for this, the answer would be that there is precedent specific to trust deed for creditors in Kinmond. Kinmond is the case about trust deed for creditors. And the important point is that Lord Traynor construed similar provisions about a discharge as saying that it was the final distribution as the trustee determined it to be. That's really the key. So there is precedent. And the third point about this is that otherwise we do enter into an area where, as my learned friend says, in no trust deed, could anyone ever be certain, beyond payment of 100 pence in the pound, that there is a proper termination of the trust, because there is always the possibility that there will be an unknown asset. We've been through PPI. One reads in the newspapers now, people are beginning to think that there might now be, the next wave might be pensions mis-selling. There's always the possibility of unknown things, let alone always the possibility that great Auntie Jeannie in Australia has died and I'm about to inherit money. So what my learned friend says, the way out of this is that the trustee and the debtor agree that there should be a composition, approach creditors and propose a composition. If that's the answer, then we will stop using trust deeds, because there's no need to use a trust deed to have a composition with creditors. One would simply go directly to a composition with creditors.
Ms. Warren, am I right in thinking the trust deed was not a protected trust deed as at the time it was executed?
That is correct, Lord.
Because it's becoming a protected trust deed depends on subsequent steps being taken by the trustee.
That is correct. That is correct. Complying with the procedures in Schedule 5, Lord, yes.
Yeah.
And the ability of non-exceeding creditors to challenge it for a limited period of time. So there's a limited window open. And indeed, my Lord, I've shown your Lordship the bar to the debtor bringing sequestration proceedings. There's equally a window, a short window of a few weeks when a creditor may elect for sequestration instead of a trust deed, even protected trust deed. So my Lord is correct that when executed, it is simply a prospective protected trust deed.
Well, one, it has the possibility of becoming a...
That is correct.
And if that's so, can you really rely on provisions in the statute to do with protected trust deeds as an aid to construction of the deed itself?
Well, my submission would be yes, in the sense that one would be envisaging at the time that this would be a protected trust deed. If it is not going to get protection, for example, if there's sequestration instead, then in terms of Clause 11, the trust deed comes to an end. It's entirely superseded by sequestration. Is the obvious example. So one would be entering into it in the expectation that it would be a protected trust deed. And in fact, this one did become, within a matter of weeks, a protected trust deed. And one would envisage that that was the way it would work. In following through this question about the choice, first of all, I should make the point that we are dealing with a trust deed of a certain vintage. I will simply give the court the references. Lord and the Chair asked about the 2008 regulations. It's paragraph 26. It's at page 672. It tells us that the 2008 regulations only applied prospectively. It's at page 672 of the bundle.
Yes, yes.
These regulations apply only to trust deeds granted after the date these regulations come into force. And we helpfully see from the way Westlaw reproduces that they came into force on the 1st of April 2008. So it didn't apply to a 2006 trust deed. So far as the 2013 regulations are concerned, it's paragraph 31 at page 719. It's, yes.
And you say that has to be given a sensible construction.
Yes, Lord.
Yes.
Yes. But I accept what my learned friend says. It says what it says,
Yeah.
but one would assume that what it means is that the 2008 regulations continue to apply to such trusts as it did apply to. Apart from anything else, it gives requirements for what would be a protected trust deed and the likes. So it's my submission that properly construed, we are dealing with a protected trust deed, as I've said, of a certain vintage. That is the one that is regulated by Schedule 5 that I've shown the court. There are then 2 points that I really need to deal with. The question is acquirenda, and then finally a comment on Kinman. So far as acquirenda is concerned, as my learned friend says, this trust deed, as it requires to do to be protected, brings within the scope of the trust all property covered in effect by Section 32 of the 1985 Act. And Section 32, it is, in fact, Section 32, subsection 10, it's at page 378. In this section, a relevant date means a date after the date of sequestration and before the date of the debtor's discharge becomes effective. Page 38. So acquirenda is caught if it's acquired on a relevant date. That's between the date of sequestration and the date of discharge. It is significant, Lords and my Lady, that this trust deed does not refer to Section 54, the question of discharge. It has its own provisions about discharge. But 3210 meets, until the Bankruptcy Scotland Act 2016 changed matters, it meets the obvious and practical point of any insolvency that one would expect the assets to be covered to be not only the prior assets, the assets before the insolvency event begins, but any assets acquired while the insolvency event subsists. So that's the reference to discharge.
Yes, I mean, you say that it doesn't expressly refer to the 3-year automatic termination, the automatic discharge, but clause 1 of the trust deed does say, refer to the rights and assets which would vest in a permanent trustee.
Yes, Lord. I accept that, Lord. And the difficulty is, though, it's Section 54, if one looks at that, at page 380. In Section 54, there is a 3-year period as the natural or automatic assumption. But then beyond that, there is means, in particular in subsection 3, for the permanent trustee or any creditor not later than 2 years and 9 months after the date of sequestration to apply to the sheriff for deferment of the debtor's discharge by virtue of subsection 1 above. Now, that doesn't apply to a trust deed. What does apply to our trust deed, if one looks at page 243, is paragraph 10. the discharge of debts. This trust deed is granted by me on condition that the creditors acceding to the trustee shall discharge me of all my debts due to them on the termination of this trust. So it's not a 3-year period, it's on termination of this trust. And Roman numeral 1, my trustee reports that in his opinion, I've not made fair and full surrender of my estate, or it's superseded by sequestration. Now, superseded by sequestration is not relevant. But 10.1 is the provision that in this trust deed is mimicking section 54, subsection 3, but there is no provision for access to the sheriff. And again, there is no surprise about any of that. This is intended to be an informal, less costly method, so one wouldn't necessarily envisage applications to the sheriff. It's simply dealt with automatically. And my learned friend made a point in opening about the relationship between clause 10, 1 and 11. If a trustee were to be of the opinion that the debtor had not made a fair and full surrender of his estate in 10.1, in my respectful submission, it would be difficult to see, in terms of clause 11b, that such a trustee would certify that there has been a final distribution of my estate. The very fact that he harbours suspicion that there is more estate would mean that he's envisaging that he's able to give no more than an interim dividend, and would most certainly not be regarding it as final. And coming back to paragraph 9 of Schedule 5, you would not be granting the certificate that the distribution had been in accordance with the trust deed, because he's labouring under the apprehension that there is a problem. So here, this trust has a mechanism whereby the discharge and the termination of the trust are linked properly to the opinion of the trustee. They are not linked to section 54 and an automatic discharge after 3 years. And this, in an introduction to Kinmond, but starting really at White against heritable, Northern Heritable. I'm afraid I've not brought enough copies, but I can make them available.
It's not in the electronic.
Sorry, it's not. We'll not find it actually in that. I was going to make the point. White against Northern Heritable, my Lord. Yeah. The House of Lords decision on which my learned friend relies. Yeah. It's at tab 12. Its page begins at 555. Yeah. I'm only going to go back to 1856 in relation to the ever-changing sort of legislative approach to when a discharge should be granted. But at the time of White, in 1856, in terms of section 146 of the Act, I apologise, I have only one copy and I can pass that to the court. I have only one copy available just now. And it's written in a style which is of its date. It's quite difficult to read quickly. But what it provides, my lords, is that there was a means for the debtor to secure an early discharge, that's prior to 2 years, with consent of all the creditors. With consent of all the creditors. Without the consent of all the creditors, there was a right to seek a discharge from the sheriff after 2 years. And of course, a creditor could object. And again, what Professor McBride explains in his book is that part of the reforms that came about was to change to an automatic discharge with, in terms of Section 54, the opportunity for a creditor to object. So it was inverted because, of course, a bankrupt is, in a sense, inevitably the last person who will be able to afford to make an application to the sheriff for discharge. But at the time of White, there was a means of securing a discharge after 2 years. And the reason why White is distinguishable is that in a trust deed, bar the provisions that we've seen in paragraphs 10 and 11 of this trust deed, there is no automatic right. That is my submission. My submission is Section 54 does not apply. There is no automatic right. We therefore have to construe the deed. And that's why White and Northern Heritable is in quite a different chapter. And if my learned friend were correct in his approach, Lord and Lady, I don't propose it. It's simply the provision we will see it starts with an automatic right. A right to a discharge if there is no objection.
Yeah.
Then about halfway through the paragraph, one will find provisions that begin to tell us about an application to be made. I'm very grateful. The Lordship's officer has reduced or returned the highlighted version for me, which is really what I need. Yes. It begins 11 lines in, halfway across a line, and the bankrupt may also present such a petition on the expiration of 2 years from the date of the deliverance. So it was a 2 year. But the practical problem about this was that the bankrupt had to have the means, i.e. the finance, to make an application to the sheriff, and of course few did. But there was a means of discharge. If, the final point in relation to this before I turn to Kinmond, if my learned friend is correct that the answer here is that Section 32 is qualified in its application to trust deeds by Section 54, then the mystery that Professor McBride spoke of in 1993, he's after all looking at exactly the legislation we're looking at, just never existed. The mystery about when the trust deed came to an end.
Well, that depends whether the definition of the assets that go into the trust were in terms similar to Clause 1 of this particular trust deed.
And that's one of the problems he also speaks of, my Lord, that there was slackness in relation to the definition of the estate. Yes.
Because if you were to say, all my current assets and all assets that I acquire during the currency of the trust, then there would be a real problem. What Mr. Howland's point is, as I understand it, is that the concluding words of Clause 1 are designed to tie in what goes into the trust to the terms of the Bankruptcy Act. Now, you've given your answer to that.
Yes, Rod, and I'll leave it there. As I've said, the mechanism whereby in terms of Section 54 there's a means to defer is present in our trust deed but dealt with separately. So this is not a case where there is an automatic, in a sense of unavoidable, 3-year discharge. That is not this case.
It would, I suppose, be even more odd if in a private trust deed of this kind, the trustee had administered the estate and got to discharge in under 3 years, if the incorporation of the Section 54 date would lead to a continuing acquirender of property in circumstances where the estate had been distributed.
That is correct.
There's no reason to assume that the operation of a private insolvency of this kind is going to take even 3 years.
Yes. Yeah. And in particular, Lord, the other point is, if he's thinking that he's not had a full disclosure, then he all of a sudden finds himself with a 3-year window only to try to sort this out. It doesn't make any sort of sense.
Your point is that either way, it doesn't make sense to include Section 54 as part of the vesting provision in Clause 1 of the Trust Deed.
That is correct. There is no need for it because there is a delay mechanism here. Yeah. And barring the question of error, there is no benefit because, as I've said, apart from anything else, this whole question of a staggering trust, one that the end of which is not known, is a problem not just for someone like Mr. Davidson or indeed Dooneen who deal with him. It's a problem for the trustee. Is Mr. Mond even today properly discharged? So that really takes us to the case of Kinmont.
Would that incidentally mean that if the possibility of the existence of further assets meant that there could be no certain discharge, the trustee would be under a continuing obligation to look for them?
Yes. And indeed, and that's the whole point about the question of the discharge. What Professor McBride says is the obligations of the trustee can transfer to his executors, in other words, his personal representatives on his death, so that there may be a claim against his estate. So even his executors have to worry about the possibility of a continuing trust. And as Professor McBride says in his article, one of the horrors as a trustee is to bequeath to one's heirs an open trust. So far as Kinmont is concerned, the argument relates to section 65 that the court finds set out at page 504 in the bundle. Section 65 is set out as a footnote. If I simply give the members of the court a chance to read that. It's essentially an administrative, a convenient administrative provision. But with respect to the learned friend, I suggest that there are two practical answers, because he says, in effect, that if the trustee does not purchase the shares, then the trustee has no claim upon them. I submit that that is wrong. There are two obvious means of claim. The debtor has two rights deriving. First of all, he has a reversionary interest, which means that when the secured creditor has realised sufficient of the shares to pay his debt, the debtor can ask for a transfer of the remaining shares back to him. That's the first right. And in an insolvency situation, whether a trust deed or a sequestration, that would be an asset of the bankrupt that would vest in his trustee. So the reversionary right would vest in the trustee. The second is exactly the remedy that was being used in Kinmont. An action of count, reckoning and payment, an action of accounting. and again, forgive me if I'm unnecessarily translating, I don't know what the English equivalent would be, but in effect, it's a means by which an individual who has given property to an agent or a trustee can ask him to provide accounts.
It'd be an accounting.
An accounting, I'm grateful to my Lord, of his intromissions, and the court can determine the balance due to the principal, in this case, the debtor. The debtor's right to an accounting is plainly an asset of his estate that would vest in his trustee. So by either of those means, a trustee can bring the balance of the shares within the scope of the sequestration. And we see in this particular case that there was no doubt but that the case was approached with this sort of argument in mind. So if one looks at page 569, page 569, we're looking at the argument.
No, 569's...
oh, sorry, but I apologise, 508, I apologise, page 508. I apologise, page 508. I'm looking up, not down, my Lord, I apologise.
Yeah.
Page 508.
Page, yes.
We're in the argument that was made to the inner house. Halfway down, just by noticing, we see halfway down there's a line begins, behoof of the creditors, halfway down, behoof of the creditors, and then there's the argument. And if it was held that the trustee was functus, the creditors could get a new trustee appointed who could raise the question with the defenders. And of course that is footnoted to refer back to White against Northern Heritable. One of the points I've raised about what this has to do with Mr. Mond as the discharged trustee. Does he have really any right to intromit? But then towards the foot, the last 2 or 3 lines of that submission, so if your lordships, my lady, find towards the foot, argued for the pursuers, it's the indent, argued for the pursuers. Just above that, 3 lines above it, at the end of a line, you will see by that clause, the pursuers were reinvested only if there was payment of the debts in full or payment on a composition. So this is very much taking the point that's being argued here, that the bankrupt, the debtor, or Mr. Davidson, is revested in his estate only if there has been a payment of the debts in full or payment on a composition. And that explains, in effect, the observations of the 2 judges. Lord Traynor proceeds to deal with it as being akin to payment of a composition. And one finds Lord Traynor at page 509, is the passage that the inner house relies on, and it's halfway into the paragraph. I'm sorry, my lords, I should say, if one looks at 7 lines in, the line begins, which it entitles them. His Lordship says, the only point debated, which seemed to me to call for attention, was this: that the right to the reversion now claimed by the pursuers was, or might be, a right which the trustee was bound to vindicate in the interests of other creditors. So it's seen as the right to reversion. As I've said, a self-evident approach to dealing with the balance of the shares. Is that Lordship then continues, But to this, the answer seems conclusive, that no one has now any interest except the pursuers. Simon, as I do notice the time.
Yeah.
Under the trust deed to which the creditors acceded, it was made matter of contract that on receiving a final dividend as declared by the trustee, the pursuers should ipso facto stand discharged of all claims ranked on their estate. And then he goes on to equate it to a composition. So he is dealing with the question of the reversionary interest. And to finish, Lord Kincairney is quite clear in his conclusion at page 511. The pursuers might have called the trustee as a defender in this action, or taken means to have it declared that the trust of the trustee having been fulfilled, the radical proprietary right, that's the reversion, reverted to them subject to the defender's security. But I agree that proceedings with that object were not necessary. Broads, I do see I've overstepped the mark, but unless I can assist your lordships and my lady, I would invite the court to refuse this appeal. I do apologise for overrunning.
Thank you, Mr. Moynihan. Mr. Bartos, anything to add?
My lords and lady, I have nothing to add.
Thank you. I think you have 3 minutes.
I wish to devote some of those minutes purely to the Section 54 point. What my learned friend has done is fallen into the very error from which I attempted to save my Lord Reed when he put the Section 54 point to me. One has to ask oneself, what is the purpose for which we have to look at Section 32? The sole purpose is to ascertain what assets would vest in a trustee in bankruptcy if this were a sequestration. Now, one can answer that question only in the first place by reference to 32(6), because that identifies the assets, but it identifies them by reference, among other things, to their falling in on a relevant date. So we must know, we must find out what the relevant date is.
Yes, you rely on subsection 10.
And then subsection 10 of itself doesn't tell us a great deal unless we look at subsection 54, which answers the question which is posed by subsection 10. And what I say, I think I mentioned the expression crossing the conceptual lines, we're not concerned when looking at the vesting clause with knowing when this debtor under this trust deed is going to be discharged. We're concerned solely with what the provisions under the Bankruptcy Act are for the discharge of the bankrupt, because it's those provisions which determine what after-acquired property is going to fall into the sequestration. And that's why I say my learned friend is in error in saying that Section 54 doesn't apply. If it doesn't apply, we can't even apply Section 32 properly.
Yes. Thank you very much, Mr. Howland. Well, we're grateful to counsel and to all those who've assisted in preparing the appeal on both sides. We'll consider the arguments and issue our decision in due course.